What's the difference between a persuasive precedent and a binding precedent? But for a better understanding between binding precedent and persuasive precedent, you need to understand the classifications of courts. Courts in Nigeria are classified under superior courts and inferior courts, courts of record and non-courts of record. A court is said to be a superior court of record if it does not have any limitation as to the monetary value of the subject matter that comes before it. They are also not under any form of supervision by another court. A court is said to be a superior court if the status creating it states that it is a superior court. For example, Section 6 sub 5 A to I of the 1999 Constitution stated that courts mentioned there are superior courts of records. Direct contrast of this is inferior courts of records. So these are courts that have limitation as to the monetary value of the subject matter that comes before them, and they are under the supervision and control of another court. Examples are magistrate courts, area courts, customary courts of appeal, etc. The next classification is courts of records. So courts of records are courts that all their acts and judgments are contained in documentary forms in order for reference to be made to such decisions in the future. The direct contrast is now non-courts of records. We will now move down to the difference between binding precedent and persuasive precedent. A precedent is said to be persuasive if a court is not bound to follow such a decision. So meaning that the court can give a judgment or deviate from applying the decision. For example, the decision of the High Court of Enugu State is merely persuasive to the High Court of another state. In the case of Police Authority of Huddersfield against Watson, the court held that a court is not bound to follow the decision of another court of equal jurisdiction. For example, the decision of the Federal High Court of Abuja is merely persuasive to state high courts. Also, the decision in Sharia courts is merely persuasive to customary courts of appeal. You cannot contrast this with binding precedent. So binding precedent is the direct opposite of persuasive precedent. What this means is that a court is meant to recognize and apply the decision of a higher court of hierarchy. For example, if a state high court is sitting on a matter and the Supreme Court has given decision on a matter similar to that, the state high court is bound to apply such decision. Also, the decision of the Court of Appeal is binding on lower courts. If you find this content helpful and valuable, remember to share the video and leave a like as well. Ask your questions and we'll do our best to provide an answer. Thank you for engaging in the next legal space.